Well, we know that it is a big legal and political week for the Israel-Hamas crisis as the matter goes before the International Court of Justice this week. Let's hope we can bring up now UP Mapungubwe Institute for Strategic Reflection Senior Associate Professor Garth le Pere. Prof, good evening to you and welcome. Thank you very much for your time. Hopefully our line holds. Israel is going to be represented by British barrister Malcolm Shaw, who has reportedly previously provided legal advice to the country. No doubt he will be pushing for the court to reject instituting any injunction ordering Israel to suspend military action, and the US administration, we know, has declared South Africa's submission to be meritless and counterproductive. How do you see their case shaping up? This is the Israeli case.
Well, I think, the Israeli case, in the face of the incontrovertible evidence adduced in this 84-page application by South Africa, which essentially contains sort of three parts, right? The first, it depicts very carefully and thoughtfully what has happened since 7th October in terms of the Israeli response, the horrors inflicted by the IDF on the people of Gaza. The second, which is just as important, in 10 pages, it demonstrates genocidal intent. That genocidal intent has to do with, choreographing the movement of entire population, 2.3 million, from one part of Gaza to another, and then, systematically, especially since the end of the ceasefire, the end of November, inflicting grievous harm and damage and destruction and human suffering on these innocent people, the civilian population. And then the third, it also is very careful in describing the historical context, particularly relying on numerous UN reports over the last 75 years. Now, it is an unprecedented application, particularly in terms of the remedies it asks for, as far as Article 9 of the ICJ statute is concerned. And those provisional measures, while the case continues, must be immediate. And it's the provisional measures is immediate ceasefire and then allowing humanitarian aid to enter.
What about the Israeli side then? And we will talk just now about the judge that they've appointed to represent their position on the bench. We've heard from our reporter just now that some of the inflammatory Israeli rhetoric, which is, what will probably be, what is going to be incited or invoked in this case from the South African side, doesn't reflect official policy, the country says. So how do you see their case shaping up?
Well, I come back to the power analytically, conceptually, legally, and morally behind the 84-page South African application. It will be very difficult for Israel to sustain an argument based on the same kind of evidentiary base. So, notwithstanding, Israel represented, as you say, by on each side, a very astute legal mind. Think about the legal team that represents the South African case, all senior counsel, John Dugar, Adila Sim, Tembeka Nkatobi, Max du Plessis, and so on. So, it's a very compelling case that I think it has a certain kind of moral power to it, which is unprecedented. And and to argue genocidal intent as convincingly as this document does will force the 15 judges of the court to seriously consider the case, notwithstanding the kind of case that the Israeli side musters.
Right. Well, you talked about the bench. Well, the court has 15 judges. Each country can nominate one each. South Africa has nominated Dikgang Moseneke, the former Deputy Chief Justice, and Israel is bringing former Supreme Court President Aaron Barak. And no doubt throughout the course of the week we'll talk about the process that will follow. But I want to end with this, Garth. Orders from the court have been ignored in the past. We know Russia rebuffed its order to halt the invasion against Ukraine after the court said in March of last year, among its provisional measures, that the Russian Federation should immediately suspend military operations. What could be different this time?
Well, I come back to the the essential thrust of this document, which is in terms of Article 9 of the ICJ statute, to ask for urgent provisional measures, and the court has to grant that within a certain period, within a week. It has to grant these two Article 9 measures, which is the immediate ceasefire, which is binding, and then the opening of humanitarian corridors to allow aid to the suffering people in Gaza. Now, granted, in terms of international law, which is often observed in the breach and violated with impunity, I think this will get to the UN, the General Assembly, at a certain point, and I think there will be many other countries, simply from a normative moral point of view, that will join South Africa's application. That is, I think, the importance of this, even if, as we expect, with the support of the United States and the fact that South Africa will probably, suffer certain, levels of chagrin from the United States. The fact of the matter is the moral power of this argument.
Don't forget to move us,
All right, we're going to leave it there. Professor Garth le Pere, thank you for your time. We appreciate it. Garth is UP Mapungubwe Institute for Strategic Reflection Senior Associate.